Hi everyone, welcome to a new episode of Law Pod. I'm Matteo.
And I'm Sofia.
I'm currently studying law at QUB.
And I'm studying international human rights law at Queen's University as well. And today we're going to talk about copyright law and how it's impacted by the rising power and effect of artificial intelligence.
And we actually have an expert on this topic here with us today, Professor Frosio. Good afternoon.
Thank you so much for being with us today.
Good afternoon, everybody, and thank you very much for having me.
So, to start us off, how about you just tell us a little bit about yourself, who you are, and what it is that you do exactly?
Yes, so I'm based here at QUB, at the School of Law, and I'm the chair of Intellectual Property and Technology Law. And plus, I also direct the Global Intellectual Property and Technology Center, GIP Tech. And in terms of my field of expertise, I've been focusing very much on the regulation of artificial intelligence in recent times, but my background is also very much IP related, and in particular copyright related. And in addition of that, I've been doing quite a lot of work on platform regulation, internet regulation at large.
It sounds super interesting, and I feel like we have here the perfect person to talk about these topics. So just to break the ice, we would just like to start by asking you, what is the current state of copyright law and its relationship with artificial intelligence?
This is one of the hottest issue on the table about copyright law. So basically, one of the major questions that has been under discussion recently is whether training artificial intelligence might trigger copyright infringement. And there are basically a couple of important aspects here. One is whether using protected content might trigger infringement at the training stage. And the other important question is whether output generated by artificial intelligence might infringe copyright. There's plenty of litigation ongoing at this very point in time. More than 50 cases are open in multiple jurisdictions, the vast majority of them in the United States. But there are important cases. There's one important case, get images under pending in the United Kingdom, number of cases in Europe, and we are awaiting for the first decision from the European Court of Justice on artificial intelligence training and on the liability for infringing outputs generated by a machine. So there's really very much going on at this time.
Okay, so I'm curious. You had mentioned that there are two sort of separate things. There's the use of copyrighted material in training these AI models, but then separate from that, there might be copyright with just the output. Are those two separate legal issues, or are they kind of being tackled together at once?
Yes, they are separate issues, but most of these cases might tackle them at the same time. But they're definitely separate issues. One issue is an issue of the potential liability of the artificial intelligence developer, the AI lab, for training the machine. And it's an issue about whether by using protected content for the training, they might be infringing copyright over that protected content used for training. And here, there is a technicality to understand. Traditionally, copyright law does not protect ideas. And when you use copyrighted materials for training, it's not to use the expressive value of the copyrighted material, but it's to extract data that then serve to train the machine, so-called machine learning, so that after the training, the machine will be able to generate outputs. On the other side, instead, there is also an issue regarding whether when an output is generated and that output is infringing upon copyrighted works because that output is so-called substantially similar to a protected work, who's liable for that? And this is where the question gets even trickier, because there is a line of thought thinking that the service providers, the AI lab, the developers are liable for each infringing output. Another line of thought instead believes that it's the user, the one prompting the machine to produce that specific output, that might be liable. And this is one of the questions that now is pending before the European Court of Justice.
I see. So, in this sort of conversation about who's liable for the output, traditionally, what is the view? And do you see the law changing in regards to that?
Traditionally, it's hard to say because there's no tradition about this. This is a very novel issue. And it's the first time we're faced with this type of issue. I mean, of course, we have, by comparison, by analogy, we have other cases that we can use. But here, basically, the idea is the developers are creating a neutral machine, a general purpose, I'd say, cultural machine that, via its training, then gets the capacity of creating an infinite amount of content. On the other side, then, as a result of this capacity of the machine, then the machine outputs an output that is infringing. It does that via, obviously, the intervention of an end user that asks the machine to do something. So now here the question is, was that the infringement was caused by the liability over the infringement belongs to the company that trained the machine and gave the machine the capacity to create any type of output, both infringing and lawful, or the liability depends on the user that through prompting has induced the machine to spit out that specific output. I have my position here. I think that liability should sit with the user, but it's wholly unclear what courts are going to do. And in fact, this important case now pending before the European Court of Justice, like Company versus Google, has as the fourth refer question exactly this. Whether is the developer or the user liable for infringing output generated by a machine? My position here would be that the AI developer is placing on the market general purpose tool, a neutral tool, which can produce both lawful and infringing content.
Mm-hmm.
But the actualization of the infringement, the generation of the infringing output depends on the prompt that the user provides. So my conclusion is that liability should rest on the user unless the software company, the generative AI company, training the machine and then marketing that machine has not put in place the necessary safeguards to avoid the generation of infringing content, which is what usually these companies do. They put in place safeguards, roadblocks that are meant to avoid blatant infringement to happen. But notwithstanding that, user can circumvent these safeguards in order to have the machine spitting out the content that they want to be generated. On top of that, there's also additional issue related to this notion of memorization. In some issues, in some situation, although the machine is not designed to regurgitate infringing content, it might happen, this is a bug of the model, not a design, it might happen that sometimes the model might regurgitate verbatim strings, verbatim excerpt of content. And it might happen, that might happen because those necessary safeguards that should be implemented in order to fulfill a duty of care are not in place.
Okay. That makes sense.
I was wondering, Professor Frosio, so you say that a case can be brought to a court of law if there is proof that there is substantial similarity between the AI-generated content and the original content. But what's the development so far in terms of the features, the characteristics that the AI-generated content must have in order to be similar enough to be unlawful?
Oh, no, that would be exactly the same under traditional copyright doctrine. So the notion of substantially similar work, that doesn't change, regardless that is generated by a human or by a machine. Now, if under the traditional standards, it's going to identify substantial similarity, so it's going to say that enough have been taken of the protected content to trigger infringement, that would be infringing what is generated by a machine or generated by humans. So there's no specific notion of substantial similarity for works generated by the machine. We will apply the traditional notion that we have applied for brick and mortar copyright.
And for the people who are listening and are not familiar with copyright law, what are these features?
These are very much defined by courts, but the fundamental principle is that in order to have a copyright infringement, you need to have taken a protectable expression. Instead, taking anything that does not amount to a protectable expression, but is still can be characterized in the domain of ideas, that would not be triggering infringement. Then, of course, there are multiple doctrines that courts apply in order to identify whether two works are so-called substantially similar. But the basic point is that in order for being substantially similar, you must have taken enough of the protected expression to trigger the infringement.
And for the users who might unintentionally breach the law and copyright law by making specific requests to the AI, in case the responsibility falls within the user, how do you have an idea of how we could make it possible so that the users know what they can and cannot do? Because the average user does not know what the line is. So is there a conversation ongoing on this topic?
So first of all, as things are standing now, the vast majority of the cases are brought against the developers, the AI company. Actually, basically all the major AI companies, generative AI companies, those placing on the market, LLMs, so-called LLMs, have been brought to court. And we haven't seen very many lawsuits against users. But actually, I think yesterday or this morning, I came to know that has been filed the first case against a user for using a machine and prompting a machine to output infringing content in Japan. But the vast majority of cases that I mentioned to you, because there's really many cases pending, they're all targeting the companies. And they target the companies according to what I mentioned to you before, because they claim that the company, via training the machine with protected content, they have infringed copyright. And they claim that when the machine spits out an infringing output, that infringing output is the outcome of having used infringing content to train the machine. So, in terms of practical suggestion for the user, I mean, I don't think that we are inventing the wheel here. So copyright works this way. It is a called strict liability offense. It doesn't depend on your knowledge that you are infringing copyright, or your willingness, or it doesn't depend on any intention infringement. But if you create something that is appropriating protected content by just blatantly copying it, or just making a so-called derivative work that includes a protected element, then you are an infringer. So I don't think there is any specific suggestion here that would be different from the traditional suggestion of do not infringe copyright in the real world. So now what's going to happen here? Obviously, users might like to generate an image via using famous character, Disney character. It would be the same thing that if we draw ourselves an image of Mickey Mouse that now is not in the public, at least the initial version of Mickey Mouse is not protected anymore. A Steamboat Willie finally fall in the public domain. But let's say that we are drawing a Mickey Mouse picture, and then we want to make a use of that Mickey Mouse picture. That's is obviously an infringement of copyright because that content is protected. And that would be exactly the same thing with the machine. If we instruct the machine to generate an image that includes a protected character, I mean, we are infringing copyright in that scenario.
Does it become infringement the moment that someone does something like make a character, an image in the likeness of a copyrighted character, or only once they try to profit off of that? or gain something from it.
No. It's the right of reproduction is violated at the time in which you make that reproduction. So it doesn't depend on the commercial exploitation of that. Commercial exploitation, especially communication to the public of the content, might trigger the violation of another copyright, which is the right of communication to the public. But one of the fundamental rights, the one that gave the name to copyright, is the copyright, or also known as the right of reproduction. So making a reproduction of something that is protected, that is infringing copyright.
I see. But if you were to, generally even not with AI, but just in general, if you were to use an existing likeness of something that's copyrighted, but then make enough of a distinction, enough differences from it to make it not an exact replica, then that wouldn't be infringing on copyright. That would be fine.
Because copyright as IP in general is known to be a paradox, because it's not only so. The idea of copyright and IP is that in order to provide the expansion of knowledge, the promotion of progress, we do that in a goofy way. We restrict access to knowledge for a certain number of years, because copyright as IP is a short-term, a monopoly limited in time. Now, we do that differently than traditional property because there's a number of public interest value in intellectual property. So how intellectual property and copyright is engineered, next to the propertization, the property element of it, next to what is protected, there's also a number of public interest uses that we can make with intellectual property and copyrighted content. Now, in copyright, this is especially necessary in order to protect freedom of expression. How we do that? We do that via different tools, depending on jurisdiction, but in general, something that we call either exceptional limitation or fair use in the US or fair dealing in the United Kingdom, meaning that there are certain uses which are fair, although we might trigger the violation of one of the exclusive rights, like the right of reproduction, but that violation is excused because that use is fair or is covered by an exception and limitation. It's exactly what would happen in the scenario you mentioned. Making a transformative use, or better, a highly transformative use, that is one of the standard for requirements for triggering the fair use defense in the United States. So if you are highly transformative in manipulating a protected work, that's a fair use and you can do so. Other examples of exceptional limitation of fair uses is, for example, utilizing works for news purposes or for educational purposes under caveats. But there's a whole set of conditions under which we can make use of intellectual property rights and copyright in particular. For example, one great example is parody. So I might instruct, and this is actually one of the sensorial effects that now might be applied by these generative platforms. Now, we might ask the platforms to use a certain character and cast it within a parodistic discourse, okay? But because platforms are setting up these safeguards or roadblocks in order to avoid the use of protected content, the platform will return as an answer that this is against their internal policy utilizing that character, because they don't specifically specify usually that violates copyright. It's against their own internal policies. But it's obvious that in that scenario, the platforms is preventing you from being able something that instead copyright law allows you to do, to make a parody after protected content.
So these roadblocks that software developers have put in place to protect copyright, did they come after the big case of users asking ChatGPT to make pictures inspired by the Studio Ghibli's style? Because we remember it was a big case last spring, and it was, I think, the first time that like a specific style of animation was used by users through AI.
They actually predated that. So actually, as a matter of fact, right now, you can still make on ChatGPT images in Studio Ghibli style. But that's exactly one of the key points that emerged early on. So early on, and that's one of the reasons why these roadblocks has been put in place. Early on, users started asking to make a content in the style of somebody. And now here it's quite tricky because it's uncertain whether style is something that is protected by copyright. Copyright law protects expression, but style as such might not be protected by copyright law. Style plus other expressive elements maybe, but style as such might fall more under the label of a general idea that therefore is not protected. But of course, we never had a tool that was able, a general purpose tool that was empowering people to make things in the style of somebody else. And therefore, as soon as that started happening, of course, right holders came back to platforms hard in order to ask to come up with a solution to avoid that. Because by having the platform able to produce works in the style of somebody, it was hitting hard the market share of those artists having a peculiar and specific style. So this is the reason why, even if no specific case has been decided yet about style, and there's no firm position from court about whether empowering users to generate the styles of authors is infringing or not, the platforms decided to come up with their own roadblock and safeguards in order to avoid that. So Studio Ghibli is a good example of that, but you need to realize this is not only about copyright law. Safeguards and roadblock is a very important issue in generative AI. And there's a number of safeguards that are implemented to avoid important social disruption. For example, although that doesn't always happen, platforms, generative AI, has embedded safeguards to avoid self-harm or to avoid asking information to cause a social disruption. For example, like creating a bomb or like launching a terrorist attack or committing suicide. Very often, users try to get those information in any event, circumventing, so prompting around the safeguard that has been implemented by the platforms. And of course, these safeguards, they are limited. The developer, they think about scenarios, but then there's always a room for the users to work around with prompts to the safeguards put in place by the platforms.
Okay, this is very interesting. This is a little bit off topic, but I'm curious what you think about this. Because that is the case, that you can circumvent those kind of safeguards, what is the duty of care that these AI companies owe to their users? Like, how safe do these safeguards need to be, and can they run into legal issues? Do you know if, like, at first, if you ask for aid in suicide, then they push back, but then you kind of find a way to very easily circumvent that? Are they still liable? Do they have that duty of care? What is the discourse there?
This will be very much a case-by-case conclusion that courts will reach. That's why we're waiting for court to decide this case. Now, we understand in general terms that users might be liable if they prompt so that they reach an infringing outcome. If that goes beyond a set of standard safeguards that platforms must put in place in order to fulfill their duty of care. And this is probably the starting point. Now, the gradient of those duties of care will be probably fine-tuned by courts. Now we have kind of standards in the business. And of course, there's been research, there's been studies, then set up guidelines for these standards, and the platforms implement those standards to avoid major disruption of competing rights. But then the fine-tuning in each specific scenario will probably come from courts, will definitely come from courts. You need to realize that we are in a pioneeristic era. It's the very beginning of the emergence of this general-purpose cultural machine. So we really are in a stage in which we must fine-tune the regulatory framework around it. As a matter of fact, we have no specific regulatory framework for instances of infringing content generated by the machine. We we applying the regulatory framework pre-existing artificial intelligence. And we have set up some regulatory framework like the Artificial Intelligence Act, which does not tap into this specific issue.
So you were saying that it's a pioneering field, that every day there is new discussion and new update. But what is the current state of legislation about AI in the UK, especially in the connection with copyright law?
So, the connection to copyright or nothing. So, at the European Union level, European Union has implemented the first general provision about artificial intelligence, the AI Act. You might have heard about it, which is it's a risk-based. So basically, what the Act does is set up a different level of risk depending on the type of artificial intelligence, and then provides obligation in connection to that, to the extreme obligation that might be banning that technology, okay? Down to transparency obligation, etc., etc. For example, one of the few provisions that is relevant for copyright and for models that might ingest content and then generate output that might infringe copyright is a transparency provision. So now under the Artificial Intelligence Act, there are transparency provision that platforms must fulfill, clarifying which content they've been using for training the machine. So that's the only provision that was actually included with an eye at potential copyright infringement. So if you put on the market a platform, you have to be transparent about what you have used to train the platform. The United Kingdom is moving in that direction. There was a white paper about regulating artificial intelligence, and now there is a proposal pending which substantially is mimicking very much this European Union approach in terms of a risk-based approach, but most likely is going to be more libertarian in terms that it's going to have less constriction in your capacity to market artificial intelligence. Anyway, all this has nothing to do with the issue of copyright infringement. There's no actual legislation or institutional documents there are, for example, from copyright offices, which are providing some guidelines in order to deal with artificial intelligence infringement of copyright. But there's no legislation that has taken up the matter and has regulated the matter. We might have it at some point. Actually, one important proposal under debate is whether we have to create some new remuneration system in order to remunerate those whose works have been used, even if our courts are going to conclude that training a machine as such does not infringe copyright.
Do you think in the future, or maybe it's already kind of in place today, there will be the possibility that creators decide to opt out for their content? So, like, they can legally say that they don't want their content to be used to train AI. And if this is possible, do you think that then the output that the AI will generate will be kind of like one-sided or biased because it only uses like free royalties content or just specific contents that haven't been opted out?
This is a good question also because we already have a similar mechanism in traditional copyright law. In 2019, at the European Union level, we enacted the Copyright in Digital Single Market Directive. And that Copyright in Digital Single Market Directive included text and data mining exceptions. Okay, so text and data mining is exactly what you do in order to make a machine learn, in order to perform a machine learning process. You provide content in order to extract data. So at European level, we actually decided that there is an exception that applies without any type of opt-out, but is narrow. It applies only to research nonprofit institution and cultural heritage institution. But then there is a broader exception that applies to everybody, so also to the AI lab, to the AI developers, but that can be opt-out. But so that was an attempt from the legal system to allow training, but with leaving room for the right holders to exploit the value of a potential data set that could have been created via training artificial intelligence. This, though, a provision like this one poses a number of issues from a geopolitical perspective. Now, I don't know if we want to get into this discussion. So I'll start it, and then if you think that we want to move back to the copyright, then you stop me about this. But now, of course, providing an opt-out and it's going to make harder to train artificial intelligence machine, because it's going to de facto force create a licensing market now for training materials. Now, this licensing market is going, of course, to favor the largest AI conglomerates, those who have the real market power to acquire the licenses. And this is a problem. In addition of that, if a jurisdiction is going to make it harder to train machines, it's going to lag behind in the so-called artificial intelligence arm race. Now, Europe is actually the jurisdiction that has the stronger copyright strictures in order to train machines because of the default idea under European law and UK law as well is that some copying that you need for training is infringing. Then you can apply certain exception, but the broadest one can be opt-out. And Europe having the strictest regime is also the country that lags behind on this artificial intelligence arm race. Actually, is nowhere on the map of AI development. AI development is dominated by the United States and China at this point in time. It's not by chance that both legal systems, for different reasons, don't have this type of copyright strictures when it comes to artificial intelligence development. Actually, it is said, we believe, at least information floating around that the US right now is 3 months ahead of China in artificial intelligence development. I don't know how much you follow of the debate, but one of the big things that we're trying to do now is to reach general artificial intelligence. So that is what the artificial intelligence arm race is about today. So meaning that right now we have artificial intelligence, so-called narrow artificial intelligence, that is able to do specific tasks. Now, the next goal, what we expect is going to come very soon, is the creation of artificial intelligence that can holistically operate like humans. Of course, with the computational capacity of human. You might realize which disruption it's going to bring on the labor market when that happens. But interestingly enough, this race towards the development of better artificial intelligence can be constricted by copyright strictures. And I think that the European system and the strong copyright protection is a good case study to prove that. So, on one side, of course, there is the necessity to protect, reward, compensate the authors. But if we go too far, we make it very hard to do machine learning and artificial intelligence research. And from a broader perspective, we have a competitive disadvantage at European level with other jurisdictions.
Just one clarification, if possible. When you make the difference between narrow artificial intelligence and general artificial intelligence, could you make maybe like more specific examples for the people who are listening?
A narrow artificial intelligence is artificial intelligence that does one specific task or a few specific tasks. A general artificial intelligence can do everything like a human would do. It can apply its knowledge and put its knowledge at work to any task. And this also goes together to the capacity that we are developing of artificial intelligence to being agentic. So being able to get out from the network and interact with the external world. And this is exactly the race that we're witnessing at that point in time, to get to that artificial intelligence, which can exactly do everything that humans do with the computational power. Now, it's not the end of the story, because the real arm race today is, once we reach the general artificial intelligence, is to reach what we call a superintelligence. So an intelligence that not only will be capable of acting holistically like a human, but will surpass the capacity of humans. Now, when that happens, we might be, many say, if it's going to happen. Now, this is not going to happen if we still remain in the present technological paradigm. So what we have now will not take us to superintelligence. We will need to move to a different curve of technological development. But many thinkers, in particular Geoffrey Hinton, who's the father of artificial intelligence, the one that invented machine learning and the one that he won a Nobel Prize for that, the one who understood that in order to develop faster artificial intelligence, we had to mimic the function of our brain. And he's behind the so-called neural networks development. Now, if that's going to happen, if we reach that stage, and I said it's an assumption, there's no evidence we are going to do that unless we have an important leap in technological development. And then at that point, we have to share the planet with an entity, a being that is more intelligent than us, which is something that we never had to face in history. And you know very well what humanity has done to all the others, to the rest of the natural kingdom, less intelligence than humans. I mean, then the hope is that if we go towards direction, that's ever going to happen. The machine, the superintelligence, will be some sort of a steward of humanity. But that's not obvious. Geoffrey Hinton is actually mentioning, now that's probably also a call to regulation, that there is a 20% possibility that in between 15 and 20 years, humanity will go extinct if artificial intelligence, superintelligence is going to come. He's saying that, besides whether we should trust that forecast, he says that because he's calling for an important regulatory intervention to avoid setting up or to avoid racing to superintelligence without the necessary safeguards put in place. But that's a big issue. There are scenarios in our technological development that we cannot predict, but it seems very much that we are jumping into those potential scenarios. At least we are investing so much money to get there without thinking about a plan B, without thinking about how to avoid losing control. The point is quite obvious. It's unknown in the history of the natural kingdom of this planet of an inferior being that can control a superior being. Again, it's an assumption. Maybe it's never going to happen, superintelligence.
Since it is just an assumption at this point, and just, it might not even happen, are there even safeguards that we would be able to preemptively put in place to ensure that this doesn't happen? And if there are, then would that be at the expense of technological advancement? Where do you think we go with that?
We don't. I mean, I think that the answer can only be no. Because if we ever generate, actually it's an assumption, but there's plenty of research, plenty of scholars, plenty of scientists that say that it's a very realistic possibility, which was not 10 years ago. Just 10 years ago, that was just science fiction. Now it's something more than science fiction. This is an important point. Most likely not, because whatever we are going to do in order to control that superintelligent machine, if an entity is super intelligent compared to us, we'll always be able to circumvent anything that, any type of tools or solution that we're going to put in place to control it. That's exactly the point, is a known of an inferior being, less intelligent being that can control a more intelligent one.
Very interesting.
But I feel like there is kind of like a paradox in this, because you are saying that we need to put roadblocks and safeguards so that the superintelligence does not become more powerful than us. But I think in the moment that the super AI becomes more intelligent than us, then we won't be able to put safeguards to that, because it then would mean that we are still smarter than AI.
No, yeah, of course. When I talk about safeguards and roadblocks, I talk about those that apply to the existing artificial intelligence at this time of development. Now, when we talk about regulation of superintelligence, we talk in terms of setting up a regulatory framework that is going to work towards this goal in an ethical manner, and also maybe considering whether we want to get to that goal. Maybe considering whether it's a good idea to develop something that could look like superintelligence. So this is very much a philosophical debate at this point in time, because rightfully, as you said, Actually, if we really get there, then the discussion about roadblocks and safeguards
It's
is
over.
really going to be hard to be even envisioned. The point is, should we go there? How we should proceed with our development of artificial intelligence? And one of the big questions and big issues that we're really not thinking about that. Also because there's this big geopolitical problem. Of course, the first one that gets to general artificial intelligence, the first one that then in the future gets to superintelligence will dominate the planet. Then you can imagine an incentive for different governments to go there. And you can imagine that moderation that might become an issue, and thinking about that in terms of careful steps might not be really what is going to drive governments at some point.
Not to sound drastic, but to me it kind of sounds like there's a chance that human greed might cause the end of the world.
No, exactly. There's a lot of research, a lot of discussion exactly about that. And this is what some of the most beautiful minds on the planet are working about. Actually, there was a petition, and there were like thousands of great scientists that were actually asking, and not long ago, just a couple of months ago, I think was the last one, were asking to stop, to interrupt, to ponder the research in the field, and not to move forward any faster before we have understood exactly what are the consequences and what we can do in order to avoid negative externalities, if not dystopian future.
I see. So it might be in our best interest to take a step back, realize what it is that we're doing, make some rules, figure it out, and before we progress more with the rate that we're progressing at.
It's harder to say yes, though, because if we get the super intelligence on anything super performant, that means that we might cure cancer. That means that we can zero poverty. That means that we can travel the stars. We're really on the edge of a potentially incredible revolution because, yes, generating machines so capable, and that not only it goes together with also development of quantum computing, can really open scenarios of wealth in which humanity can profit very much. Now, here is a big issue that also is linked to the one related to copyright, because there is the issue emerging as well. I mean, of course, though, if we don't redistribute the resources coming from this revolution, there's going to be a number of people who are going to left out and who are going to be left behind. And here, what we see, also because we had this trend in the economics for the past 50 years, is that the conglomerates tend to internalize all the resources. So unless we come up with solutions so that the incredible resources that are generated by artificial intelligence are going to be shared with society at large, then we are in only for a dystopian future. So this is the big challenge now. And in copyright, this discussion is very much on the table right now, because these machines, although they might not be actually infringe copyright, they are taking away slices of market from creatives. Think about a translator is creative. A copy editor is creative. Those jobs are gone. Of course, right, most of the news you read are written by artificial intelligence. Increasingly, the music that you listen is generated by artificial intelligence. Think about, what's better than artificial intelligence to generate the potentially most popular hip-hop song. A hip-hop song that might not be brilliant, but everybody's going to like. Nothing could be better artificial intelligence to cater the exact taste of the public in a certain moment. And actually, so hinted in this. So here is an interesting point to be understood. Now we say, oh yes, but we already got through this. We had the Industrial Revolution, and of course we had to readjust, and we did. What happened in the Industrial Revolution? During the Industrial Revolution, we started substituting manual labor with machines. And then what did we do? We reconverted ourselves and created more intellectual labor-based jobs. But if now, as Hinton says, artificial intelligence is going to take over, this is what statement that he makes, it's going to take over all the manual intellectual jobs in the next 10 years, say like something like that. What's left for humanity? We have lost a big chunk of the manual labor. At this time, we might lose an important chunk of intellectual labor. There's nothing else then. We cannot reconvert to something else. Of course, there will be room to reconvert and to do something more intellectually engaging. But given the pace of development of these models, we might really expect that there's going to be little apart from absolute creativity or high-level thinking that the machine is not going to be able to do, let's say, in the next 5, 10 years, because realize that, guys, 5 years ago, this didn't exist. We didn't even have ChatGPT 0 5 years ago. Now we have 5, and 5 performs so much better than 3, 3.5, and 4. It's a quantum leap between the two. And that's just in 6 months. If every 6 months the development is this, most of the white-collar jobs could be gone soon. This is the reason why there is, on the copyright side, we talk about remuneration mechanism that we need to implement in the law, even if the actual training or use of the works is not infringing. Because even if it's not infringing, this is because copyright law could not take into consideration a general purpose cultural machine. So we need to introduce a new redress mechanism to allow people whose market share has been hit by artificial intelligence to recoup some value. So remuneration in the copyright domain, and in any other domain, we are talking about something very similar, something that has been known for many years as universal basic income. Or somebody even talking about, I haven't mentioned a guy so far, Elon Musk, of course, is very vocal about artificial intelligence. There's something that I share with him, the idea that in order to cope with this big revolution, we'll need to move towards transhumanism at some point. We'll need to be augmented if really the direction is towards superintelligence to conserve. We need to move towards what I like to call the homo artificialis. But of course, this is long term. But short term, in order to redistribute resources, we might need universal basic income. And as Elon Musk says, maybe, and that's quite good, universal high income. Because if artificial intelligence is going to be so productive and is going to produce so much value, we could really be in for a treat. Or we could be totally annihilated by the machine. So that's why it's hard to say, let's not do it. That's why it's a huge conundrum for humanity.
I feel like we could have enough content for another episode here and have so many good conversations. And I feel like the author Isaac Asimov, he wrote about sci-fi and in a future where
he talks about that.
And he was right.
That's actually the final lesson from Asimov. In the last book of the Foundation, Trevize, if I'm not wrong, the name of the guy traveling looking for Earth, is landing on the moon, and then he meets the last robot. There's no robot in the Foundation universe. And the last robot says that at some point, robot decided to go, leave humanity, because they realized that humanity with them didn't have purpose. This is one a big issue, and I'm very philosophical, but with the advent of something like a superintelligence. That even if superintelligence is not going to kill us all, which seems improbable, I say, because if it's so intelligent, we don't kill animals out of spite, so it probably should do better than us, although we don't do perfect. But the big question would be that if we have such a super intelligence living with us, what's our purpose? There's nothing we can achieve if there is an entity so much better than us. And that's actually a great lesson from Asimov. This is what he actually says. He explained that robots decided to leave humanity because the existence of robots and took any purpose away from humanity.
Wow, that's really terrifying, but also really interesting. Yeah, I feel like we already took a lot of your time, and it was super interesting, and I feel like I learned a lot from it.
Oh yeah, I agree.
Yeah,
likewise, I learned tons. This was fantastic.
Yeah.
Thank you
I had
so
a lot of
much.
fun, and actually, guys, if Don't get me started talking about this because
Yeah.
I'm writing a book now about this very topic. So I'm deeply immersed in thinking about artificial intelligence.
Well, thank you so much for your time. Thank you so much for your insights. And thanks a lot to our audience. We will see you soon. Thank you so much, guys.
Take care.
Bye.